We have major breaking news. This is extremely geeky and very high-end stuff involving something the United States Supreme Court has just decided in a huge case that's going to have a major effect on cutting back the ATF's authority. We're going to have to get super geeky on this one, but you're going to be very happy with the result. Stay tuned. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Make sure you check out that book. It's now available in audio as well as paperback and more. Okay, folks, so here's the story. The United States Supreme Court has just decided in a case called Sackett versus the Environmental Protection Agency, a very big decision that is extremely good for gun owners, although that conclusion is not obvious except to the people that are sort of in the Supreme Court world and track, among other things, laws relating to administrative agencies such as, yes, indeed, the ATF. Specifically in the case of Sackett, and it's pretty clear that the ATF is in big trouble. It's coming down the pike. It's going to be a day of reckoning for them. That is where all the signs of this U.S. Supreme Court, taking a look down the chessboard, is going. And I'm going to tell you why. To begin with, just before I get into the case of Sackett, which was just decided by the Supreme Court involving the EPA, I want to remind you that the United States Supreme Court has already decided to hear a case next term. They've already granted certiorari in a case called Loper versus Raimondo, dealing with a very technical issue involving a federal statute known as the Magnuson-Stevens Act, dealing with the governance of fishing boats. No need to get into the details there. The bottom line is there's a fight about what the government's executive branch wanted these fishermen to do versus what the statute said. And what's important about that is the Supreme Court granted cert on the following question. And we've talked about this before. Whether the Supreme Court should overrule Chevron versus the Natural Resources Defense Council, right? Chevron versus the NRDC, or at least expressly limited in some way. So what we have here is that many, many years of administrative agencies such as the ATF expanding their authority and making stuff up, and under the Chevron doctrine, the rule was since 1984 that if there's any ambiguity about the scope and powers of these administrative agencies, even if these agencies' interpretations touched on like criminal laws, the courts were supposed to defer to the agency's interpretations of these laws because they were the quote-unquote subject matter experts in various things. So the ATF, because they are the quote-unquote subject matter experts of firearms, therefore they had an extra special say as to how the laws governing and giving power to the ATF could be interpreted, and courts would defer to those interpretations. This is totally wrong and unacceptable because, as you know, under basic rules of our Constitution, the executive branch, which is the presidency, and the administrative agencies are to enforce those laws. And where do they get those laws from? They get them from Congress, right? Congress makes the laws. The executive/presidency enforces the laws given to them by Congress, and who interprets the laws? It's the third branch of government, the courts. But what happens under the Chevron doctrine, that the executive branch responsible for enforcing the laws were given the authority to interpret the laws, which was really taking away the power and the role of interpreting the laws from courts. Totally unacceptable. And this allowed the executive branch, the presidency, and all these administrative agencies, whether it be the FDA, the EPA, the ATF, the SEC, all these alphabet agencies were able to interpret the laws in ways that were most favorable to what they wanted in the broadest possible way. So if you're representing like an FFL and you get some letter in a dispute about what the bound book means or something like this, the ATF would inevitably cite the Chevron. Hey, when in doubt, we win, you lose. And of course, the Supreme Court is now starting to say that's not the case, which is why in the Loper versus Raimondo case, they're specifically saying, should we now overrule Chevron? That is indeed what they intend to do, because I don't think they would have granted cert with that question presented unless they intend to do exactly that, which is to get rid of this terrible Chevron doctrine. Now, why is all this relevant to what just happened today? Because this huge case just came out showing that the handwriting is on the wall for agencies like the ATF. It's already starting to be in big trouble for them. It's going to get worse, because in this case of Sackett versus EPA, in a decision, the Supreme Court came out and said that the EPA basically made stuff up in terms of defining a congressional statute that used the phrase waters of the United States. That was the key language here, waters of the United States. And what happened in the Sackett case, just to show you how insane the EPA was in this case, and why you can see analogies to how the ATF often behaves. In the Sackett case here involving the EPA, the language from Congress was that there were protections associated with, quote, the waters of the United States. Now, what happened in this case is the Sacketts bought land that had some pond, not a pond, it had some sort of ponds or some sort of water in the backyard that was not connected to anything, and they started to fill it in so they could build a home there, and the EPA came out and says, you can't fill in that water in your backyard. That is a water of the United States that we, the EPA, see. We conclude that what's in your backyard is the water of the United States. And they said, that's absurd. It's a pond. It's like nothing. It's our backyard. There's no water to anything. And the EPA says, no, you have to defer to us because we're the EPA and we have the benefit of the Chevron doctrine and so on and so on. Well, they go all the way to the Supreme Court, and the Supreme Court says, absolutely not, EPA. You're totally wrong. Now, some of the language is very good for us, and you're going to be very happy when I read this to you, which is why I'm telling you this is super geeky stuff. But the language that I'm reading to you now, I'm betting you dollars to donuts. The stuff I'm flagging to you right now, I can promise you, is being used by lawyers fighting the bump stock cases, fighting the ATF all across the country right now, including the pistol brace stuff. They're reading this language if they're sharp, and I'm sure many of them are, and they're looking at this stuff saying to themselves, yes, we got the ATF. Here's some of the language from the Sackett case. Even though it deals with the EPA, it is analogous to the ATF because we're dealing with the authority of presidential/executive branches to be able to make stuff up and use statutory language and just invent stuff and put things in there, even if there's criminal applications. Specifically, this is what the Supreme Court said, and Sackett is going to apply to the ATF as well. They say, quote, the court requires Congress to enact exceedingly clear language if it wishes to significantly alter the power between the federal and state power and the power of the government over private property. Bing, 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 bing. Did you hear what I just said? The U.S. Supreme Court in Sackett said that if Congress wants to alter the power of the government over private property, are bump stocks private property? Yes, they are. Are pistol braces private property? Yes, they are. Are stabilizing braces private property? Yes, they are. So the Supreme Court just issued a ruling that says that if Congress wants to alter the power of the government, that's the ATF, by the way, the power of the ATF over private property, what does it have to do? This is not Mark Smith. This is not the four boxes darn. The U.S. Supreme Court says, quote, it requires Congress to enact exceedingly clear language if it wishes to significantly alter that relationship. Now, do you think that the language involving bump stocks and pistol braces in terms of what congressional statutes say is exceedingly clear? Ha, ha, ha. Absolutely not. And that is language that's going to come back and bite the ATF on the butt. You watch. I know this is super geeky, but I'm telling you, this is how it's going to get played at this high level. It's going to work. You just watch. The second thing that Sackett says today, this is the Supreme Court in the Sackett case dealing with EPA, which spanks the EPA big time on par with what I think they're going to do the ATF. This is the second thing they say. The Supreme Court writes, the EPA's interpretation gives rise to serious vagueness concerns in light of the Clean Water Act's criminal penalties. Bing, 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 bing. Hear what I just said? The EPA's interpretation gives rise to serious vagueness concerns in light of the Clean Water Act's, the relevant statute, criminal penalties. Are there criminal penalties associated with having a bump stock, which is a machine gun if you don't have it registered? Yes, there are. Are there criminal penalties associated with having a short barrel rifle, also known as a pistol with a pistol brace or stabilizing brace? Yes, there are. And what did the Supreme Court just say in the Sackett case about this concept? Quote, the EPA's interpretation gives rise to serious vagueness concerns in light of the CWA's criminal penalties. Just substitute in the word the ATF and bump stock or pistol brace. Read it this way. The ATF's interpretation gives rise to serious vagueness concerns in light of the National Firearms Act's criminal penalties. Okay? You see what I'm saying? Because it goes on to say, and this is why the Supreme Court said that, it says due process requires Congress to define penal statutes with sufficient definitiveness that ordinary people can understand what conduct is prohibited. It cannot define it in a manner that's arbitrary and discriminatory. That's not Mark Smith. That's the United States Supreme Court. Now, we talked about this before. But this is what the Supreme Court said in the Sackett case. So as you can see where the Supreme Court is going with this language. When you apply this to the ATF, it's going to be big-time trouble for the ATF. They continue on. What the Supreme Court said also, of course, is that certainly Congress has the authority to write this stuff clearly, and if they don't do so, guess what? Can't be enforced. So let's just apply this to the concept of machine guns, because under the relevant definition of machine gun, 26 U.S.C. 5845B, well, that obviously has criminal penalties. So if you have a bump stock that's a machine gun, well, that's criminal penalties. And again, as we know, Congress has to do something that is certainly intended for the statute to cover, and that is not the case. And by the way, the fact that the ATF flip-flopped on bump stocks really does speak to this notion that the Supreme Court just talked about in Sackett today about serious vagueness concerns. Do you think, now what is vagueness? I want to remind you all. Vague and ambiguity. Vague and ambiguous. I want to make this simple. Vague and ambiguous terms are things that have more than one reasonable interpretation. If something has more than one reasonable interpretation, it's vague and ambiguous. And in this case, guess what happens? The Supreme Court says Congress has to step up and clarify. And if they don't, well, guess what? The consequence is the EPA doesn't have the power to regulate the little water in the back of the Sackett's backyard. And the ATF doesn't have the power to do these things with bump stocks and pistol braces, as I see it. That's where I think this is all going. And keep in mind that Stephen Dettelbach, the head of the ATF, just recently flip-flop about the pistol brace regulation in his testimony in front of Congress. And that's just going to speak to what the Supreme Court said in Sackett, which again says, if there are serious vagueness concerns, especially where you have a risk of criminal penalty, that is unfair and not allowed under the Due Process Clause, because if you don't have that sufficient definitiveness that ordinary people can understand what's allowed and what's not, it's totally unfair, because people can wind up going to jail for not even understanding. And now this actually touches fingers with, and I want to wrap it up here, the notion we've talked about before. There's two types of crimes in the world. Malum in se, which is evil in and of itself. These are crimes that we all just understand, even in nature, that they would be wrong. These are things like robbery, rape, murder, burglary, theft, fraud. These are just things that are inherently wrong. You know you're doing something wrong. You know something is wrong just by virtue of its nature. Now, what is the other thing, which is almost always the case when we're dealing with the ATF and these regulatory agencies like the EPA, we're dealing with something much different than malum in se crimes. We're dealing with something called malum prohibitum crimes. Malum prohibitum crimes mean they're wrong because the legislature says so. They're wrong simply because we say it's wrong. So if you're talking about water in the backyard being a waterway of the United States, there's nothing inherently wrong with that. It's just defined that way. If you're talking about jaywalking, there's nothing inherently wrong with jaywalking. It's just said you can't do it. Same way with, a barrel that's under 16 inches or more than 16, whatever it is. These are arbitrary lines. They're victimless crimes. They're malum prohibitum. And when you're dealing with a malum prohibitum crime in particular, then guess what? The Supreme Court is going to be extra careful in terms of trying to protect people's rights. All right, to sum up, the bottom line is the handwriting is on the wall, as I see it, for the ATF, involving a lot of their nonsense rules that they're making up, trying to give themselves more and more power because Joe Biden can't pass gun control law through Congress because people don't want it. So I think that the decision to hear the case of Loper versus Raimondo dealing with the Chevron doctrine, whether or not to get rid of it forever, and this decision that just came out from the U.S. Supreme Court literally in the last 24 hours of Sackett versus the Environmental Protection Agency, all this bodes very well for our issues with the ATF and the ability of us, or our goal, of course, in my opinion, is to shrink the scope of all government as far as I'm concerned, including but not limited to the ATF, which lords over the American gun industry and American gun owners with powers that, frankly, they have never been given and probably cannot be given because it would be unconstitutional, but certainly they have not been given to them by Congress. And, they just try to take on their power. But it looks like those days of just aggravating aggregating power in the name of doing so by these administrative agencies appears to be coming to a close quite quickly, given the West Virginia decision of last year. Now we have the Sackett decision, and there's more coming, including this Loper case, which I think we're going to be seeing decided between now and the end of this year. So, okay, folks, hope this wasn't too a little geeky for you. I know this is super inside baseball and connected up a lot of dots that appear at first to be tangential to the ATF and to our Second Amendment rights, but nope, it all speaks to the same topic of limiting government power and expanding our freedom, including our right to keep and bear arms. So if you haven't subscribed to the Four Boxes Diner, please do so, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.